Welcome, everyone. I am very happy to welcome all of you in this great amphitheater Laprad, which was designed in a time where gender equality was not in the Constitution, as you can see while looking at this wonderful painting. So this event is closing this wonderful week we had with students from Bulgaria, Poland, Czech Republic, Spain, and France. It's an intensive week on LGBTI issue. And for this week, I am very grateful to the European Union, its Erasmus Plus program. I am very grateful to the Ocean Network from the Council of Europe, who has enabled us to have Senem from the Council of Europe coming today. Also, I'm very grateful to the different institutions of University Lyon 2, the Direction of International Relations, who did a great job for the whole preparation of this event, the law faculty with the dean, who will say a few words, and the chief of the staff and financial issue, who help us to invite everyone. And finally, to my research institute, the Center for Critical Legal Studies, CERCRID, who also enable to have great guests coming to teach and to participate. Thank you so much, Mr. Bascoulergue, Dean of the Law Faculty, for these few words that you will say. Then we will hear an external message from the Ambassador Jean-Marc Berthon, who unfortunately was in Malta for a meeting on SOGIESC, designing the new intersex recommendation for the Council of Europe. And after that, we will have the debate with four people that I am now presenting. Raina Georgieva, who's a lawyer working at the Constitutional Court of Bulgaria. Silvan Agius, who is a former member of the EU Commissioner Helena Dalli, Commissioner for Equality, and formerly working for ILGA Europe, and formerly working for the Maltese government. And last but not least, Marcin Górski, professor in Łódź University, and also attorney and also ad hoc judge at the ECHR. Thank you so much, everyone, for coming, and I hope you will enjoy this discussion.
So, good afternoon, esteemed guests and colleagues and friends. It is with great pleasure that I welcome you to University Lumière Lyon 2 for this important conference, Better Definitions for Better Human Rights. As Dean of the Faculty of Law, Julie-Victoire Daubié, I'm very honored to open this gathering dedicating to examining how the definition we use in law and policy shapes the protection and realization of human rights. In recent years, we have witnessed concerted efforts by anti-gender movements to challenge and redefine key terms within international human rights law, particularly those related to sexual orientation, gender identity and expression, and sex characteristics. These efforts have not been confined to any one region. They have found traction in various parts of the world, including Africa, Europe, and the Americas. Such development underscores the critical importance of precise and inclusive definitions in our legal frameworks. The words we choose carry weight. They can either affirm the dignity and rights of individuals or render them vulnerable to exclusion and discrimination. As legal scholars, practitioners, and advocates, we bear the responsibility of ensuring that our legal language evolve to reflect and protect the diversity of human experiences. Today's conference brings together experts from diplomacy, international organizations, judiciary, and academia to engage in a multidisciplinary dialogue on this pressing issue. I'm confident that the insights shared here will contribute you to a deeper understanding of how we can fortify human rights protection, so thoughtful and inclusive definition. I would like to extend my gratitude to all the speakers and participants for their commitment to this cause. Let us approach today's discussion with openness, rigor, and a shared dedication to advancing human rights for all. Thank you.
Dear Benjamin Moron-Puech, dear students, Dear Benjamin Moron-Puech, dear students, thank you for allowing me to take part in your conference from a distance. I would have liked to be in Lyon, but I've been detained in Malta at the Council of Europe meeting. One of the main aims of the meeting is to draw up recommendations for the Committee of Ministers of the Council of Europe on the issue of intersex persons. Benjamin is very familiar with this subject and was one of the experts who drafted the first version of this important text. I salute his important contribution and his commitment. I will be brief. I would like to make 2 points, 2 apparently contradictory comments. The first is that on LGBT issues, as on many other subjects, we need good definitions, because we are talking about human beings and their identity. As Albert Camus said, to name things wrongly is to add to the misery of the word. To define is to draw a line that separates, a boundary that encompasses certain elements and excludes others. If I define a woman solely by her sexual characteristics at birth, I exclude trans women. That's what the conservatives are trying to do today. They try to define identities in political texts and use these definitions in their battle against LGBT people. One of Trump's first executive orders defines what a woman is and what a man is biologically. So let's be careful with definitions. Let's not give the international reactionaries a monopoly on definitions. Let's fight for the fairest possible definition of words and concepts. My second comment is in the other direction. If we have to fight for the right definitions, let's not die for them. Let's be prepared in certain circumstances and when it's for the right cause to show flexibility. In Africa, LGBT people are defined as sexual and gender minorities. This sounds bad to our ears. It offends our convictions. We don't like the notion of minority, but it makes it easier to defend LGBT people because in Africa we recognize minorities and the obligation to defend them. Sometimes it doesn't matter how vague or imprecise the definition is, as long as it helps to achieve the objective. I would add that when agreement cannot be reached, it is sometimes better to stick with vague definitions that suit all parties. Trying to be too precise in the words you use can cause disagreements to erupt. This is not satisfactory, and at some point we will have to arrive at a precise definition. But in the meantime, it is the lesser evil. The concept of gender identity in some international texts is deliberately vague. Some see it as a reference to gender equality, others to gender transition. This is a good thing because it would be difficult to make a direct and explicit reference to transidentity. I don't know if I am clarifying your subject or adding to the confusion surrounding it. In any case, that's my experience. To sum up, I would say that there are definitions that we must fight for and others that are better left in a certain certainty. I would have liked to have been there to hear what everyone had to say, especially Benjamin, whom I thank again. Thank you.
Dear Mr. French Ambassador for LGBTI rights, thank you very much for your two messages. We will keep them in mind, the message towards inclusion and your message as a diplomat to be cautious, because if you want to attain some results, sometimes you need maybe to compromise. But I'm quite sure all the other speakers will have something to say about it during the debate, which will take place also with Senem, which I forgot to mention, Senem Gürel from the Council of Europe, who's working in the SOGIESC unit. Sorry, Senem, for forgetting you in the past. Now we will have a little introduction or theoretical introduction by Pierre Michel. Pierre Michel is a colleague of mine. He is a senior lecturer in legal gender studies here. He teaches, of course, many other disciplines, but that's one of the topics he's like to research. And Pierre is also a very good theoretician. That's why I thought that when it comes to definition, Pierre was the best in place to tell us a few words about it. Thank you very much, Pierre, for helping us today.
Thank you, Benjamin. Thank you for allowing me to speak on this issue of conflicts over legal definition and their consequences for the right of LGBTEQ people. As you can hear, my English is not very good. I will hope you can understand me, and please feel free to ask me to repeat myself. Indeed, I'm going to try to show you that depending on the definition chosen, fundamental rights may or may not be respected. We could also have a talk about the term itself, the name of the word. Certain pejorative expression has been abandoned in everyday languages and legal languages. I'm thinking in particular of the term of intersex rather than the term of hermaphrodite, and transidentity rather than the term transsexuality. But to get straight to the point, some of my colleagues during this week have already told you about the recent decision of the UK Supreme Court, decision made just 1 month ago in April 2025. In this decision, the British judge had to rule on the meaning of the words sex, women and men. And the question is actually difficult for the lawyer. Indeed, the notion of sex and gender has several meanings which can overlap, but also oppose each other. At first, sex can be biological, referring to morphological, chromosomal or hormonal characteristics. But each of these criteria fail to provide a biological definition of sex. This is why it's better, and Benjamin told to you, to use the expression sex characteristic instead of biological sex. However, I will sometimes use the term biological sex just because that is the term used by the Supreme Court. But keep in mind that is more complicated. Just women as vulva and men as scrota. Second, the notion of sex can also refer to a psychosocial approach when it's referred to the gender identity. Gender identity is the intimate feeling of belonging to a gender, regardless of whether the gender corresponds to the civil status or corresponds to the sex assigned at the birth. For this reason, gender identity can be similar to a form of femininity or masculinity, even both at the same time or neither. For example, non-binary identity can mean a certain fluidity between gender, but can also be an identity emancipating itself from femininity and masculinity. Also, gender identity can be linked to individual sexuality and even take on a political dimension. Third, the notion of sex can finally be strictly legal when it is based only on the sex who is indicated in the civil status. In most countries, you know, there are only two sex references in the civil status, feminine or masculine, due to the presupposition of gender binarity. However, several countries have established a third category of sex to include, for example, intersex people, or another example, every people does not identify as belonging on the gender binarity. This is the case in Germany, Nepal, New Zealand. But beyond this issue of gender binarity, which can we discuss during the debate, I think it's very important to understand the meaning of legal sex. More precisely, I just told you there are, in a way, three sexes according a legal interpretation, but in reality there are rather two conceptions of sex: sex as biological characteristic and sex as gender identity. In fact, legal sex is simply the translation of one or the other of this conception into a legal document. To take a local example, France, because I know it. Since 2016 Act, the French Civil Code has authorized the modification of the sex designation and civil status for the transgender people without, and it's important, providing a medical proof of gender transition. Previously, the case law of the French Court of Cassation required a sterilization of transgender people, and without ongoing sterilizing surgery or an hormone therapy, transgender people could not legally change their sex. In my view, this act has changed the definition of legal sex. Why? Because before in France, the law has always considered sex as a simple constitution of the child morphological sex at birth. For this reason, legal sex always refers to a biological sex, but now, with this law, legal sex also refers to a gender identity, so people with a male sex and civil status can have an uterus and vice versa. In other words, it's now gender identity that establish legal sex and no longer the biological sex. This means that there in France an internal ambivalence in the understanding of legal sex. This ambivalence is at the heart of the famous decision of the UK Supreme Court. For several years, a strong disagreement has opposed different political movements over the correct definition of sex in the law, and therefore the correct definition of what is a woman and what is a man. On the one hand, transgender rights advocates argue that only gender identity, whether recognized in civil statute or not, should be considered. On the other hand, some activists contest the possibility for transgender people, transgender women, to be fully considered like a woman or like a man. They argue that only biological sex should be included in the law. It's in this context of tension that the Supreme Court of United Kingdom was led to rule on interpretation of sex, women and men, in the light of two major texts. One, the Gender Recognition Act related to sex change, and two, the Equality Act, which creates a rule of concrete equality between women and men. For the Supreme Court, the term sex refers to a biological definition. Consequently, according to this decision, British law defines the term woman as only people with a female anatomical sex, and the same for the men. This decision, like say the ambassador, excludes transgender people from the gender-specific rule, such as the maternity leave, toilet, bathing area, sport competition, parity, etc. We can speak about the justification of this interpretation because its legal reasoning is very fragile, even dishonest. Just to take one example, the Supreme Court of United Kingdom states that the literal meaning of sex is biological sex. However, as in France, legal sex includes in UK dual meanings between biological sex and gender identity. But the Supreme Court Act is the various rules on sex change have not redefined the legal sex. I will spare you the other weaknesses of this decision to discuss what is this clash tell us more precisely about the definition of sex and gender. Defining legal sex is not a simple debate between legal scholars who want to write a legal vocabulary. On the contrary, it's a central issue for the human rights and the rights of LGBT people. Because affirming that sex is only biological has the direct consequences of denying the existence of transgender people. This denial of sex change in civil statute directly harms transgender people as they are relegated to their birth sex. In my point of view, this interpretation could constitute a violation of Article 8 of the European Convention, as its jurisprudence protects personal autonomy and therefore legally acquired sex. The European Court has said in the decision Von Kuck against Germany that the essence of the Convention being respect for human dignity and human freedom, and this is why the Convention is a protection given to the right of transgender people to personal development and to physical and moral security. So a biological definition cannot satisfy this standard. Besides, it cannot be argued that respecting the rights of transgender people is achieved at the expense of women's rights. Due to the principle of sex equality, gender-specific rule has been neutralized the past year for the most part. The rule still in force relate to a biological fact, such as pregnancy. The biological criterion can be taken into consideration when relevant. The rule of protecting pregnant women applies the same to pregnant men, because beyond the gender, it is the state of health, the pregnancy in this case, that is protected. Respecting the right of transgender people, transgender women or transgender men, does not limit the right of women, cisgender women. Some will tell us that sport competition demonstrated the opposite, but it is entirely possible to rethink the sport rule in a gender-inclusive way for inclusive competition, and Benjamin Moron-Puech and Helena have demonstrated this very well in an article. Therefore, the violation of the right of transgender people perpetuates a naturalistic conception of gender, a conception that was used against the cisgender woman. This, for example, the prohibition of night work for women was justified by their physical weaknesses. Other example, the submission of wives to their husband was justified by their mental weaknesses. We can also speak about the word hysterical. All this to say that many feminists have fought against the biologization of their body, of their behavior, and their minds. That fight is not yet over, and as sexist stereotypes are still very common, but the disrespect of the human right of transgender people, and more broadly of LGBT people, indirectly lead to the same result for the rights of cisgender women. To conclude this speech, it seems to me that while defining is inevitably a limitation of the meaning of the word, but it's sometimes essential to establish a definition to avoid a setback for fundamental rights, as the British Supreme Court decision sadly demonstrated. So what definition of legal sex can we adopt? Many possibilities. For example, we can clearly state that the gender identity is a central element of the legal sex. Another possibility will be to go beyond the gender binarity by adding several legal categories of sex to civil status. And a third, but other possibilities are possible. It's maybe possible to remove completely this mention of sex from civil statutes. In France, these possibilities are not discussed. The French government and legislative assembly do not want to revisit gender binarity. It's like a taboo. And I hope you understand what I say, and thank you for listening me. Thank you, Benjamin, to try to speak, pour essayer de me faire parler en anglais. Merci.
Thank you, Pierre, for trying to do this exercise. I think you succeeded. You would have a great mark. No, more seriously, I was very interested in your speech because you gave us two different ways of defining. You can make an explicit definition, that is what the UK Supreme Court is doing, but you can also change the condition of access to one right, in this case, the right to change your gender marker, and sometimes this will also change the definition itself. And the funny thing is that in this first example that you gave, they didn't try to make any definition. But at the end, that was the result of their action, changing the definition of sex. So thank you for pointing that out. So we will now enter the debate phase with 4 speakers, and we will have 2 questions for them. And I would like to have a final round of questions from your side. So please, if you have some question for Pierre, write it down now. And if you have some reaction to the first round of question, write it down, because you will have the opportunity, half an hour, I think, to ask your question at the end of the 2 questions I'm going to ask. So my first question is the following, and Ambassador Berthon has partly started to answer it. So for you, who are judges, who are legal experts working in courts, legal experts working in international organizations, who may sometime have written some text, who may have sometime delivered some decision, written some conclusion in cases that you're in charge. For you, why are definitions in SOGIESC, meaning sexual orientation, gender identity, and sex characteristics, so why are definitions so important in your position regarding SOGIESC human rights? Can you give us maybe 1 or 2 examples that you met and where you really understood how important such definitions were? And we will follow a simple rule. Senem, maybe you can start, and then we will move to Raina, Silvan, and Marcin. So each of you.
Hello again. Good afternoon. I will give my answer via a PowerPoint presentation that I would like to share now. I hope it will work with the screen share. Let me try with this. Slideshow.
Yeah, it's working perfectly.
It works. Yeah. Okay, there we are. Yeah, why the definition is important in SOGIESC human rights protection is I can give just briefly my first point of view that terms and definitions used in legislation contributes to creation of legal standards. Sorry, I may lower the volume of my audio because my sound echoes. Let me. Sorry for keeping you waiting. Yeah.
I've got the mic. I've got the mic on our side, so it should be better also.
So let's try again. Slideshow. Okay. Yeah, I was saying that it creates legal standards and defines the conditions and scope of protection that is provided to the groups and individuals. And most importantly, these definitions contributes to legal certainty. It provides legal basis for victims, having the victim status for individuals that enables them to bring these claims before institutions and authorities and ask for remedies in case of any breach of their rights. For criminal law is also considering the importance of the principle of no punishment without law. Particularly, definitions and clarity is important in that field. And for example, when it comes to the hate crime or hate speech legislations, it's important to explicitly refer also SOGIESC grounds as the prohibited grounds of bias. So when it comes to the Council of Europe work and SOGIESC unit's work, actually our unit name is also an example of evolution in terminology. It used to be, when it was established, the unit was established in 2010, it was called SOGI, only referring to sexual orientation and gender identity. Whereas with the evolution of the term, gender expression and sex characteristics were added in the name of the unit. I'm not going to go into the details of related to the definitions of terminology, because I believe all last week, all the students as well as the experts aware of the differences between what is sexual orientation, gender identity, expression, and sex characteristics. But what I can refer to is now how in the Council of Europe entities and conventions these terms are used and defined. For example, when it comes to the protection of SOGIESC in Council of Europe treaties, is the first treaty that comes in mind is, of course, the European Convention on Human Rights. And there we can see that the provision prohibiting non-discrimination had the open-ended list of prohibition grounds. However, on the basis of the case law of the court, as being and interpreted the convention as the living instrument, it confirmed that sexual orientation, besides gender identity, besides later on in years, especially with the recent case which is pending before the Grand Chamber, the Semenya versus Switzerland case, now the sex characteristics are also acknowledged. In contrast of the European Convention, which was a treaty adopted in 1950, that time all these grounds were not really established in the legal sphere. In contrast to that, Istanbul Convention, the Convention on Preventing Violence Against Women and Domestic Violence, which was adopted in 2011, it was the first international convention which explicitly included the sexual orientation and gender identity as prohibited grounds. And that enables also the providing protection in cases of intimate same-sex partner violence provided by the convention, Istanbul Convention. So when we look at the European Court of Human Rights judgments, we can see that the LGBTI rights has been discussed or dealt with by the courts since 1980s, and the evaluation is observed on the concepts of what is private life, on the concepts of what is family life, and also the state's positive obligations. As you can see in the list on the slide, the case law of the European Court started in the 80s with the decriminalization of the same-sex relations, which was related to sexual orientation, and then it moved on to the recognition of legal gender recognition related to gender identity. It also established standards on gender reassignment and the procedures that it's developed, saying that, for example, it needs to be transparent, accessible, the procedures, and without certain requirements of, for example, sterilization or divorce or other surgeries and so on. So those are through the case law, those legal standards have been established. Along with that, in the recent years, the court also requires some sort of recognition of same-sex couples and their relationships in terms of family life. It doesn't have to be marriage, but it should be the states in their legislation should provide some sort of recognition of these partnerships and couples. And also, we also observed the development of positive obligations, as we mentioned, that especially in ensuring the exercise of freedom of assembly, LGBTI public events, like the court requires the state authorities to provide safe and peaceful environment for the participants of these assemblies to enjoy their freedoms and rights. So what's important about the court's case law and its interpretation is that even if the case is related to against one member state, but this interpretation and these legal standards applies to all member states. And member states are, of course, obliged to implement these decisions. One good example that I would like to refer here is Valianatos and others versus Greece case. Why is a good example is because of two aspects. One is the fact that European Court took the emerging trend as a basis to define the right of recognition of civil partnership regime for same-sex couples. And also it's a good example that related to implementation of this judgment by Greek authorities, that after this judgment has passed, to execute this judgment, the Greek authorities adopted a law in 2015 enabling access to civil partnership regime by same-sex couples. So these are the kind of positive effects of the court and the development of legislations. And when it comes to the terminology, we can observe also in the case law that there are linguistic differences in terminology in between two official languages in English and French. We observe that more and more now the French also translation started using gender identity instead of sexual identity. In the previous case laws, there were always, even if the original judgment in English refers to gender identity, the French versions, as I noted in some of the cases on the slide, were referring and using the identité sexuelle. So sexual identity normally, as you all know, that it is a narrower interpretation than gender itself. But more and more in the recent years, we can see that this gap has changed, and also linguistic differences have become lessened. What is also important is the development of this Council of Europe standards not happens only the basis of the binding conventions, but also its non-binding Council of Europe instruments contributes to the development of terminology and legal standards. One of the important instrument that also enabled our unit to establish is the Committee of Ministers recommendation in 2010. It is on the measures to combat discrimination. And again, here in this recommendation, as we can see, that it refers to sexual orientation and gender identity only. But these are the non-binding treaties, but they constitute minimum standards, and they also assist the member states to develop their own legislation and policy frameworks on these matters. And also, because these standards are part and integrated as the Council of Europe standards, European Court, for example, refers to them. For example, one case, as I noted in the slide, is the Hämäläinen versus Finland. We observed that the court referred to this recommendation concerning the case related to legal gender recognition. And these also recommendations provides the basis for emerging trends and interpretation of European consensus by the European Court. because we know that the European Court case law doesn't develop or evolve in isolation, but it is a part of an international law and standards. So these non-binding treaties also cross-fertilize each other and feed into each other.
Well, thank you, Senem. Do you...
Sorry, let me...
Because we try to have 7 minutes per question, so everyone can have time to answer it. But maybe you want to shorter your answer to the second question.
Okay, I heard you. Okay, let me... if I try to show you some examples maybe of how this cross-fertilization happened in between the Council of Europe's other standards is, for example, I can give an intersex example where the Commissioner for Human Rights published an issue paper on intersex person in 2015, and this followed by the PACE resolution on promoting rights of intersex person in 2017. And it also followed by ECHRI's monitoring. ECHRI is the European Committee Against Racism and Intolerance. Has established all the standards on intersex children rights through their country reports, monitoring reports. And these now the standards are also leading to the Committee of Ministers recommendation that is now in making. It's a new draft recommendation on the equality of rights for intersex persons. So these are just the general examples. If I may then conclude, I will just jump into the summary section that what's important to remember is the definitions evolve with time, and that does also have an effect on the scope of protection provided by legal standards. And protection provided under the European Convention has evolved also, we observed in the case law, as the basis on the principles of living instruments and based on the emerging European consensus on these issues. Cross-fertilization between different Council of Europe instruments also contributes to expansion of rights. And what's important is that these recommendations, these reports also assist member states in their development of laws and policies to effectively define and prohibit these groups against discrimination and hatred. Thank you very much.
Thank you, Senem. So I found interesting how you showed us the process through which the Council of Europe with multi-state actors, internal actors are trying to improve the definition step by step. This is an interesting point of view from international organization. How does it work in a national court, like in Bulgaria? Raina, could you give us also some reason of why definitions are so important? And yeah, go ahead.
If I stay or can I stand up?
As you want, as you want.
Okay. Let's be equal. Unfortunately, law operates, unfortunately, with words, with speech. And if in poetry, interpretation is something pleasant, like in any art form, in law, it's very important that most of the people understand the words in the same way, so it could have its normative effect. And 90% of maybe legal disputes are disputes about words and definitions, and if something falls into a certain definition. And sometimes no definition is better than a bad definition, because at the end, no matter how smart we are, life is always richer, and if there's some discretion given to a court could use the basic principles, apply them to a case and get a better result than when trying to work with a really bad definition on the one hand. I will never forget how when I studied UK law, English law, because it's very different from our system. All of the people here I heard are from the continental legal family, not common law. So in the criminal legislation, there were such definitions of rape or poisoning with so much explanations in them, You could not fall. If you do this and put this and this in a person's this and this, then it's rape. Then if it's something else, it's not rape. If you give someone a pill that makes them go to the toilet for 2 months, it's not poisoning. But if you give them only something that could kill them, it's poisoning. So if there was just the word poisoning or rape, it would be much easier to apply from our perspective. That's the first, because a definition could include, exclude, or it could create chaos. It could create something that's not rule of law. When norms are conflicting, they're like a mechanism in a machine, they start blocking each other. Also, because human rights are more and more above the state, supranational, international, and we inevitably always use translations. Like with the Istanbul Convention in Bulgaria, the biggest problem wasn't that judges didn't know English, French, or people didn't know what gender is. It was that the translation that entered the parliament and was supposed to be the applicable version of this act was very poorly made. So it's very important who does the translation, and also during the negotiation process, there's democratic legitimacy issue here. And it's not because international organizations are trying to create definitions and define our life. It's maybe because the people who represent the nations or the governments or the people in the negotiation process of drafting maybe are not also voicing out in a timely manner and talking to all of the interested parties in time, not to wait for something to be adopted and then wonder, oh my God, how am I going to translate this now? What I mean by no definition is better than sometimes a bad definition. Most conventions, treaties, and constitutions contain words like democracy, like rule of law, like human dignity, the principles of the French Constitution. These just mean a different thing at different times because society evolves. Maybe rule of law in Nazi Germany is not our rule of law because we evolve, we are a different society. And it's very bad in terms of strategy. You mentioned yesterday what a strategy is. When governments or courts don't have a strategic thinking and they look back, whether they interpret treaties or constitutions and words, even when there's a definition, if they look only historically and traditionally with no vision to the future, then they don't interpret evolutionary the words, then even the best definition cannot help. And that's pretty much it for me.
Thank you, Raina. I found interesting that in your talk, and this was also in Senem talk earlier, how the plurilinguistic issue can also complicate or bring new resources for the definition process. You mentioned something regarding the Istanbul Convention, maybe just for those of you who are not aware about it. Bulgaria refused to ratify the Istanbul Convention because the definition of gender in the Bulgarian version was very bad. And it was very confusing, mixing sex and gender, and the conservatives used this definition to make huge cases about it, leading the path to other anti-gender movements all around Eastern Europe. So indeed, sometime maybe we should not define the words if we want to avoid some backlashes like the one happened in Sofia if the definition is not good, including the translation of the definition. From your point of view, Silvan, why are definitions in SOGIESC matters so important?
Thank you, Benjamin. If I may, I will start actually with the title of the conference first and then move on to that, because it uses better twice, and it's not sure that greater definition always gives you better results. Definition can fossilize a concept. So we may be dealing with a definition of the 1950s all of a sudden that really doesn't apply to our circumstance today, and it was formulated in a particular way not because the term required that particular definition, but that was the concept at the time. So we have some of these things that we deal with. For example, in EU law, we still struggle to include gender identity fully because the European Court of Justice had to deal with cases early on in the 1920s when we didn't speak about gender identity and gender expression. Instead, the definition there is around gender reassignment, and therefore that holds us back. Just to give an example. Also, sometimes definition, a greater definition, here I may be a bit counterintuitive at first, but people seeking their own definition don't realize that if they seek it in law, they are actually locking themselves in a small box. Greater boxes, many more boxes is not greater freedom. Freedom is no boxes at all, and you can move around freely. So it's these things also that I think in definition we have to be careful about, because what applies in a paper submitted to your professor is not what should be in the law necessarily. For example, in the Constitution, where Malta, where I come from, has included sexual orientation and gender identity, you will not find a definition of those two concepts there. Much like you don't find a definition of sex, of race, of language, of any other thing. The Constitution is there to establish the concept, much like the European Convention on Human Rights is there to establish the concept. It's not there to give us a definite definition, which is what helped us as we went along to have case law that addresses it. So, speaking about the case of Malta, for example, so as I mentioned, we already have sexual orientation, gender identity in the Constitution that were introduced 11 years ago now. Subsequently, we adopted a law to address gender identity, gender expression, and sex characteristics in law. And there, of course, the definitions had to come. So that law has definitions on gender expression, gender identity, gender marker, lived gender, non-binary gender, and sex characteristics. So some laws require it, other laws don't require it. It's the purpose, therefore, that establishes the need, and not how to say, almost an urge to throw into the law definitions by way of adding anything extra. I don't know if I'm clear on this, but greater definition is not always better for the people who may be victims of discrimination or who may require access to a particular service.
Thank you, Silvan. Definition or boxes. So indeed, we should be cautious when deciding to put ourselves in two boxes. Is human rights is freedom? Freedom is not putting ourselves in boxes, indeed. So in your position, Martin, what do you think about the importance of definition in the context of SOGIESC? Do you have any example to give us?
Thank you. As a lawyer, I'm generally obsessed with definitions. I think that we all feel. Law must be foreseeable, must be predictable, and definitions contribute towards foreseeability. So I cannot but agree with Senem, who said that definitions increase legal certainty. On the other hand, they reduce the scope of judicial, I would say, appreciation, so the margin of appreciation that judges must enjoy. Law must be a smoothly operating engine, and any engine needs oil, right? So this is like oil. It makes the engine work more smoothly, perhaps. That's one thing. My personal encounter. It was really hilarious. In the course of the strategic litigation that we had in Poland concerning legal recognition or legal institutionalization, well, institutionalization is legal by definition, okay, institutionalization of same-sex couples, we had this constitutional court stage. And now a short information here. We don't have a properly functioning constitutional court in Poland. We have more like something pretending to be a constitutional court and in fact operating as a political, as a body responsible for imposing political views more than anything else. But in the course of these proceedings, we had to go to the Constitutional Court. This is because 20-something years ago, the European Court of Human Rights ruled in the Szot-Medyńska versus Poland case that when a particular right or freedom is protected, both in the Convention and our Constitution, the exhaustion of domestic remedies in our case would require a constitutional complaint. So we did. And we obtained, obviously, there were like several litigations. In some of them, they were not yet decided by the Constitutional Court because one of its characteristics, as it stands now, is that it is inoperative. So it doesn't basically work. People take money, but they don't work, right? But in one of my litigations, I obtained the order of the Constitutional Court. It was obviously the order on inadmissibility, and it was surprisingly very wise. It referred to Article 18 of our Constitution, which according to some far-right politicians acting as lawyers, should be read as a sort of horse collar. You know what is a horse collar? When you ride a horse, the horse wears this horse collar that allows you to stop the horse. So this is their perception of the chapter of the Constitution pertaining to rights and freedoms, that it is used to stop people from, some perverted thoughts about exercising their rights and freedoms. So the provision reads, marriage as a union of a woman and a man. If you go on a website of the Polish Parliament, the translation is marriage being a union of a man and a woman. That's slightly different, isn't it? So marriage as a, jako in Polish, as a union of a man and a woman, singular, as well as the family, motherhood and parenthood, shall be placed under the protection and care of the Republic, right? So it basically means that there is one form of a marriage composed of one man and one woman. I'm not being mean here, so I'm not asking about age issues. How about 5 years old people? One man and one woman, and their marriage is under protection and care. It means it is a policy guidance for the government, any government, to implement a policy of protecting this type of marriage, which obviously does not mean that other forms of marriage cannot be established, right? And in general, this is chapter 2 of the Constitution, rights, freedoms, and one obligation, to defend the country. Rights and freedoms. It should not be construed as a horse collar, right? It is, for God's sake, a shield, not a sword against citizens. So that's it. So definitions. And what I got from the Constitutional Court was, surprisingly, a very smart, very wise interpretation that, okay, this provision does not mean that nothing else can be protected. That's what we said. That's what we've been advocating for like 20-something years. That it is not like an exclusionary provision. It is inclusive, right? And so, yes, definitions are absolutely important. And just one remark to what Pierre said about for women Scotland limited versus the Scottish minister's case. I have to be careful because, when you are an ad hoc judge, you never know when is your role to be played. So I will be very careful here, but I will just quote a few words because you said quite openly that what they said in the UK Supreme Court amounted to the violation of, I guess, Article 14 in conjunction with Article 8 of the Convention, right? Okay, I'm not sure whether it is such a turf victory. So I cannot agree that it can fully be treated as a J.K. Rowling case, right? Okay, what I find, some excerpts from the reasoning. Relatively few trans people have gender recognition certificates in Scotland. I don't know how they calculated it, but okay, they said there's like 20,000 transgender people of either sex living in Scotland, and relatively few of them have these certificates. And the judgment concluded if they were treated differently to those who do not have certificates. The court stressed that it is not its role to define in abstracto the category, the legal category of a woman or of women. It is solely for the purposes of a particular provision of law, the provision that guarantees a certain quota in the composition of management boards, right? And the court also stressed that among the people whom the Equality Act recognizes as having protected characteristics are women whose protected characteristic is sex. And transsexual people, they put it in inverted commas, thanks God, transsexual, I don't like it, transsexual, whose protected characteristic is gender reassignment. So what the court essentially found there was that you had different characteristics in their law. The only problem is that when you attempt defining, right, you may have side effects. And to me, for women in Scotland, is like a huge side effect. I don't feel this, this mean intention behind it, perhaps. It is a side effect. So they try to interpret something. They found that they have this different protected characteristics in law. And they say, okay, if you have transgender people and women are protected in terms of representation in management boards, right? So say you have some sort of quotas there. And they're also transgender people, so they should be treated differently. Obviously, the impression we have is that what they said is like excluding transgender women from the category of women. So J.K. Rowling probably had a glass of champagne that evening. But she did? A cigar. And a cigar. There is a beautiful passage in this judgment that one of the NGOs have the impression that it wasn't particularly progressive, raised that you don't have to undergo any physiological changes. I don't want to be extremely mean, but I would be careful if I were J.K. Rowling. I'm not sure whether she would survive the test, if that was the case. If we are talking about physiological issues, which is absolutely stupid to me and sense makes no sense. Oh, that's a beautiful picture. Thank you.
Thank you, Marcin, for pointing out these kind of side effects. It reminded me another decision from the Bulgarian Constitutional Court, which in its attempt to define sex and gender, it's an Istanbul Convention, said that sex was a biological thing. And then there was a huge side effect because later on the Supreme Court of Civil, Court of Cassation in Bulgaria, decided that also when it comes to apply the change of sex marker rules, it should be only biological. And therefore this decision by the Supreme Court was later on used by some judges in the Court of Cassation as a way to close the door to any kind of legal gender recognition in Bulgaria. Let's move to the second question now. So once more time, in your position, did you ever had to write some definition regarding SOGIESC? And what kind of difficulties have you encountered in this drafting process? And if you did not have to write such definition, but you had to apply them, what kind of difficulties you had, especially if the definition was not so good? Could you give us some information? I don't know, Senem, if you want to speak again, but maybe this time for 3 minutes, or you said everything you wanted already?
I can just quickly mention three issues regarding that. I will take the question from the point of developing new standards at an intergovernmental committees at the Council of Europe with 46 member states. It's of course challenging because the level of understanding, the level of protection provided in those member states in their national laws and policies there is a big variety and varied. So agreeing on a text, agreeing on a definition and scope of obligations, of course, is challenging. So that's one challenge that I can refer to. Again, the second challenge is because the definitions and terminologies are dynamic, and because of that we have to always check things when we do our work at the SOGIESC unit. We have got partner LGBTI grassroots organizations that we constantly do this fact-checking, terminology checking. And as I mentioned in my previous presentation, that we are in the process of developing a new recommendation on intersex persons' rights. And of course, some more details can be maybe given by Benjamin, who is also taking part in the drafting expert committee with that regard. But another study that we are launching is on gender expression, because we observe that that concept, there is no still a broad understanding on the definition of gender expression. Some states subsume this under gender identity, but with the study that we hopefully will develop this further. Another point that I would like to make is the context and the political context and discourse, which influences, of course, this process. And we know we are all observing the kind of an opposing trends in Europe. On one side, there are like progress on certain matters, but now more and more we can see the backsliding in LGBTI rights, and some hard-won rights are now under attack, are challenged. Some concepts are under contestation. What we observe is especially in the definition of gender identity, more and more limitations are put or legislative proposals are made to restrict this definition only as the gender strictly refer to male and female. While we also observe the pitting of women's rights versus LGBTI rights, removal of the gender from the legislation, making gender equality as only a definition of equality between women and men. And, the so-called protection of traditional values, family values, or protection of children are used as a basis to attack LGBTI rights and their equality. What I can refer to is also at the Idaho Forum this week, the reference made by the Secretary General, and in the same line also echoed by the Commissioner for Human Rights of the Council of Europe, that these attacks are not isolated incidents, but they are like threatening the whole democratic foundation of our societies and inclusiveness of our societies. And we can discuss all together, of course, here in this panel as well, what sort of actions that we can take to counter this anti-gender narrative, anti-gender movement, misinformation and backsliding. Thank you.
Thank you, Senem. From what you said, I also catch the idea that when you decide to define something, you also have to articulate it with other words. As you say, gender expression, how should we think about it? Is it the same than sex? Is it the same than gender identity? So this is indeed something we need to reflect on when we write a definition. Raina, on your position, maybe more on the application of a decision, what can... Yeah?
On the definition of sex?
Yeah,
like,
for instance,
there wasn't that huge of a problem until the Constitutional Court decision, and more, not the Constitutional Court decision, but the Supreme Court of Cassation decision. Because we have decisions from the 60s and 70s in socialist Bulgaria when they allowed people to change their sex. And up until that moment, there were 3 groups of case law. Some judges would always, some panels would always decide that you can change the sex on your ID, the gender on your ID, only if there was a mistake. The second group decided that you could do it only if there was irreversible transformation of your body, of your characteristics. And the third, which was the major one, thought that there should be medical expert's opinion on the case, that the person is transsexual, and that then for the court to be convinced that they have very stable decision. This is a very stable, mature decision, and they're not gonna turn back. But what was the worst, of course, people criticized the courts using maybe not always the best terminology, let's say, but at the end what the courts were missing was procedures. And they cannot do that. They cannot write the administrative procedure for moving the paperwork at the end. So this was a big challenge. Also with the other one on gender, the biggest problem was that people, and including lawyers and scholars, were mixing sexual orientation and gender identity. For me personally, I just looked at the dictionary of the Council of Europe and the travaux préparatoires to just see what is the sense and purpose of the norm. Like any lawyer would see the purpose, teleological interpretation, like these are ABCs in the world. Yes, that's pretty much it for me. Although I have a problem with another issue, is the definition of all partnerships. Now we have some very strong resistance to any sort of cohabitation or partnership being registered. This is a huge problem. Just because of homophobia, they didn't put it in the family code because then they would have to have it for all partnerships. Then this led to people being excluded from the legislation on protection from domestic violence. And recently, in last year, they had a weird new thing added to a norm in the law on protection against domestic violence, intimate relationship, standing right next to factual cohabitation, in which they also put men and women. Now in everything that's partnership or living together, they put men and woman, just like as if people that are from the same sex, they could not have domestic violence, even if they live like a couple or something else. So this definition of the Constitutional Court with men and woman, and this focus on men and women on everything, had much bigger impact than we expected.
So I'm speaking about a few different things. So when I was working at ILGA Europe around 2011 and holding the International Intersex Fora, of course there was a problem that there wasn't a ground for intersex issues. There was nothing, in fact. There was no framework. Eventually Australia adopted a form of law to address the issue, but instead of sex characteristics that is widely known today, and I'll come to that, intersex traits was used. I personally didn't like it, and I made it a point that intersex traits doesn't become the term. So what was intersex traits built upon? It was built upon the idea of disability. So if you mention the issue in the ground, it becomes the right ground. I didn't like that because I also have sex characteristics. You have everybody has sex characteristics. It's which kind of sex characteristics. And so I worked with the intersex community to develop their own terminology, in this case, sex characteristics, which I liked because it was, universal. And that, I think, was a win for the intersex community long term, that debate happened. So I'm glad about that. Sometimes definition is not about what you add, but what you remove. So back to the example of the men and women in where they don't belong, they can just be removed and suddenly the law becomes inclusive. So that's what we did, for example, with the marriage equality law. The marriage equality law was not a new law for gays to marry. No, it was just the removal of the barriers that were blocking gays and lesbians from marrying. So sometimes the thinking has to be in that direction. When we were working in Malta now for the Maltese government on a law against conversion practice, we were framing our thought at first around how to oppose something. And I kind of didn't like it, but I didn't have better vocabulary until I went to look at what the Canadians were doing in the different provinces. And suddenly I found the Ontario case, and I changed that name to Affirmation of Sexual Orientation, Gender Identity, and Gender Expression Act. And it came with a text that frames that. So it says, to affirm that all persons have a sexual orientation, a gender identity, and a gender expression, and that no particular combination of these three characteristics constitutes a disorder, disease, illness, deficiency, disability, and/or shortcoming, and to prohibit conversion practices as a deceptive form and harmful act or intervention against a person's sexual orientation, gender identity, and/or gender expression. And what does that do? It changes the orientation of the law. Rather than seeming to aggressively fight something, it's actually protecting something. The orientation changes and the meaning changes. Also, if I may, and I'll finish with this, we've discussed a lot the definitions of gender identity, gender expression, etc., but we've not discussed the definition of the actual rights. And that's crucial in my opinion. So I'll read you out what we wrote as the right to gender identity in Malta in law, and then I'll stop there. So what is the right to gender identity? All persons being citizens of Malta have the right to the recognition of their gender identity, the free development of their person according to their gender identity, be treated according to their gender identity, and particularly to be identified in that way in all documents providing their gender identity therein, and bodily integrity and physical autonomy. So that establishes all the rights right there. Without prejudice to any of these provisions, and then we bring in some further explanation. So a person's right, relationship, and obligations arising out of parenthood or marriage shall in no way be affected. So the continuity of the personhood across time. The person's right arising out of succession, including but not limited to any testamentary dispositions made in one's favor and or obligations or rights subjected to or acquired prior to the date of change. So again, continuity in time, and any personal or real right, again, continuity in time. Then the gender identity of the individual shall be respected at all times. What this tells you as a right in its formulation is that this right is not there to be broken. It doesn't come with limitations. This is a fundamental human right like all other rights. And it is this formulation that has protected many trans people against all sorts of aggressions.
Thank you, Silvan. I hear from what you say that it's not only words that need to be defined, but also rights. And to be honest, Silvan, when I was working on your law, I found it amazing because it was one of the first that was really saying what is the LG, or legal gender recognition, what it is about. And you were one of the only legislation when the rules was not only saying what are the conditions to fulfill to change your LGR, but really trying to protect, really taking the point of view of the trans community and not the point of view of the civil servants who was going to change the paper. And this was, I think, a real good move in your law. Also wanted to add, and because Senem has mentioned this earlier, that in the drafting process of the future intersex recommendation for the Council of Europe, we had huge debate around the expression variation of sex characteristics. So, as you said, in your own time, you tried to avoid intersex traits because you believe that everyone had sex characteristics, so we should find an inclusive way of protecting these, not only for intersex. And this was the same situation for me. There was a tendency to say that variation of sex characteristics is the same than intersex. And I was saying, well, we need to be careful with this, because some men can consider that they have also variation of sex characteristics. We had, during this week, a play that was performed partly naked. Maybe Martin, who performed it, think he has some variation of sex characteristics, that he's not in the norm. He told you during the play, I have it a little bit above the average. So isn't this also a variation? Shouldn't we protect it also? And so I think that what you told us also is, when you try to define, do not close the door, leave it open, so everyone can benefit from this definition. Marcin, in your position, have you encountered already difficulties when drafting definition or applying definition? Can you tell us a bit more?
Yes, I told you about the application process, but I want to mention the drafting works on the Polish, on the there were three different bills on registered partnerships. They were all rejected by the Parliament in, I think it was January 2013, after a rather outrageous debate. And what we tried at that time while drafting these provisions was to avoid defining to the greatest possible extent, because we somehow felt that that would provoke unnecessary discussions. Also, I would like to refer to the definition that Silvan showed. It's from the gender identity, Maltese gender identity legislation. And the provision, yes, if you could, again, that's the... No, down, oh, here, yes. The gender identity of the individual shall be respected at all times. It is fantastic, although I must say that with my governments, some of my governments that we had to deal with in the recent decades, that would be a provision leading to banning all inclusive education at schools. Because they would read it in the following way: you cannot produce any inclusive, education, because that it is likely to compromise gender identity of children. So that sounds, wow, that would be very dangerous in my country. Okay, so yes. About drafting the law, that was a huge thing, to avoid defining too much. These definitions, they also grow old. We had this pertinent experience of the Istanbul Convention. When we were drafting it, it was 2012 or 2011, something like that. And the Istanbul Convention was just signed, and it was literally bullied by some European politicians, and it still is every now and then. And my pinch of salt regarding definitions comes from, this incredible abusive campaign against the Istanbul Convention. That, wow, they provide for a definition of gender. This is horrible. Gender is a social role. There is nothing like a social role, and we have dishwashers, right? So because it was very abusive. But these documents, they also grow old. And when you read the Istanbul Convention, where you have definitions, women includes girls under the age of 18. Imagine how this definition can be used. If you are in bad faith, if you act in bad faith, right? That would mean, okay, so women are only biological women, because it reads here that it includes also girls under the age of 18. Definitions can also be dangerous. Having said which, I am still a huge fan of defining things, because it lets us push things forward as well.
Thank you, Marcin. So we have ended the second part of this conference, and now we have around half an hour as planned for your questions on defining issues. So please. Yes, thank you, Maud. If you can pass the mic to Maud.
Well, thank you for all these presentations. I had a rather open question. When you talked about defining openly or trying to have no boxes, like, do you think that, I'm talking about semantics here, like, is there a way we could define a box large enough to fit everyone, including future issues, or should we move more towards the no boxes at all?
I'll have to answer you briefly, I'm afraid. Otherwise, I'll have forever to answer you, maybe after this. We're human, all of us. That's what connects us. And that's why we speak about human rights. We don't need, in human rights law, reference to men and women for them to apply to men and women. So those are two boxes that we can do away with. We don't need them to refer to gays, lesbians, bisexuals, non-binary, pansexual, asexual people, right? Because all of that is not necessary the moment we have the big box called human. Also, between us, if I had to tell you all the elements that compose my personhood, it would be forever. But do you need to know any of that for us to be able to relate? No. So what are we doing with more definitions? If we are having a conversation about your particular identity and my particular identity, I have to define it to you so that you understand me, and then we can discuss. That's very specific. In all other circumstances, none of this should matter. And that's what we should fight for, in my opinion. So human rights, right to education, right to health, right to anything else, those are very clear. You don't need to apply them to a very, very small box of, I don't know, I'm a gay, cisgender, and this and the, who cares, yeah? And so human rights should not be about any of that. And the moment we go down that pathway, we create risks and problems for those others that don't have precise definitions to define who they are.
Would like to add something to answer Maud's question? I don't know, Pierre, Raina, Marcin, would you like to add something to this answer? Okay. This is my... so, other questions? Yes, thank you, Gosha.
Well, thank you so much for the presentation. It was great, very informative. I have a question for Marcin. In the last part you said, in order to advance things, you must divide them. What exactly did you mean? Is it in a judicial spectrum? What exactly should we divide there? I'm afraid I might not get the whole point that you made in the last moment.
Okay, can you say a bit more?
Like you said at the last moment, we had to divide things in order to advance. What exactly do we have to divide?
Gosh, I'm not sure what I said. Okay, in the last part, I said, among others, that we have to be careful with defining, because defining may be sometimes dangerous, and also definitions, they grow old, and they can be abused. That's all I said. I'm not against definitions. I just think that we should be aware of that and be cautious.
All right, so it's more like uniforming the whole definition spectrum.
It's just the experience of coming from the country where they managed to use a human right against humans. That's the example of Article 18 that I gave you of our Constitution as a horse collar. When I read this fantastic, by the way, law that you drafted in Malta, I simply realized that the social background is different. The legal, cultural background is different in your country. And in my country, that would be very dangerous, this provision, right?
Thank you.
Yes, actually, to respond to this, because there was a point at which Malta and Poland, in terms of approach, didn't differ too much. So it's not like we have a strong legal tradition that, you know, like, say, Sweden and the Netherlands, that have systematically been like 20 years ahead of everybody. Malta wasn't that country. So what permitted this, of course, is the fact that our social conditions, I will spare you the details, but it actually started in 2011 with a referendum on divorce legislation. Malta did not have divorce law, and then the referendum opened up divorce for heterosexuals only. That was because only they could marry. And so that, however, broke the tradition until then of this understanding that what the Catholic Church said is actually shared by the vast population, which is, I think, the understanding in Poland today to some degree, that whatever the Catholic Church is saying, we should be careful not to rock the boat too much around it, right? And so we had already introduced sexual orientation and gender identity in law in 2014, the year prior to when this law was put forward. And so when this law was put forward, it had a constitutional basis all of a sudden. Only 1 year old, but it mattered. And so in this law itself, then we define gender identity, which refers to each person and not each man and woman's internal. You know, so everything is framed away from this binary gender concept. And so one thing to tell you, by the way, which I think is very important, it's very much linked to this. In none of the laws that the Maltese government adopted while I was a director for human rights and migrant integration, in all that period, I made sure, and the government eventually in its legislation did follow through, that there is not a single reference to gay, lesbian, bisexual, transgender, or any other category of this kind. Because I really don't believe that there is anything that pertains to us specifically. I have the right to gender identity, I just won't exercise it. It's that level simple. So in law, we didn't need, so back to the idea of the boxes, this links. I don't need to be excluded from that box, I just will not go to it because I don't need it. And so, yes, only fashion, nowhere else. Thank you.
Is there other questions? I'm sure there are. I will ask two round of questions while you're reflecting to your own question. My first question is for Senem. Senem, I heard that at some point the SOGIESC unit was trying to adopt a glossary, that it was taking a lot of times. I don't know if it's possible for you, if you're allowed to, but I would be interested in knowing why it's taking so much time. What kind of issues internally or externally you're facing? And my other question is for Pierre Michel. You said, I think, if I understood properly, that the definition that the UK Supreme Court is giving of sex is a violation of Article 8. And so I have a question on this. Is it possible to say that a definition per se is a violation of human rights, and per se, despite any sort of application, even if it has never been applied, is a violation of the convention, and therefore you can sue your state and ask for some money for this violation? Thank you in advance for your answers.
Yeah, if I may, Benjamin, on your first question about glossary, Council of Europe, European Committee Against Racism and Intolerance has a adopted glossary concerning all grounds of non-discrimination. And besides that, SOGIESC UNIS publications, for example, the publication on the legal gender recognition or the recent thematic review on health standards, access to health standards and access to health care by LGBTI persons, they all have little index and glossaries. But actually, there hasn't been any agreement or an official glossary yet. It might be, again, because of the current political context. It might be because of the situation of the Istanbul Convention, its definition of gender vis-à-vis others. But certainly, on other recommendations, for example, the recommendations I referred earlier on combating hate crime, it refers to the personal characteristics and includes all those. So in certain publications, you can see the list or key terms, but the glossary has not been adopted yet. On the previous issues regarding the definitions, I'm enjoying the conversation on whether more definitions are needed or whether we should leave things in a more like a open-ended phases or not defined, not to exclude groups and people. I think in this current context, these are like really relevant discussions to be made, because the more drawing attention to certain terminologies, more backlashes that we face. Of course, this is also goes to draw parallels with the whole universality of human rights, but also some groups, because they have been marginalized and systematically discriminated, whether they require more protection, and if so, through which mechanisms and by which tools. So we observe that if certain grounds are not explicitly added in the legislation, they might be, because of the political context, they might be ignored, or judges might say that, oh, but this is not said, so I'm not really referring or applying this protection guarantees to those groups. So it's a kind of a fine line, but as we said, it's the best is the legal frameworks are to be clear, but at the same time to be broad enough to be all-inclusive and all-encompassing.
Thank you very much, Senem.
Thank you, Benjamin. I don't think a definition can be itself contrary to the human rights, because the definition is supposed to describe some reality. I agree with my colleague that we must be careful about strict definition, but we must be careful too about the complete absence of definition. What I want to say in my speech, but you understand my English is not very bad, is not very good, is that the strict conception of sex, like just biological sex, can be, could be, and not can be, violation of the human rights and the European Convention. But the European courts could very well say that is a proportionate violation of Article 8, because the concrete equality is a substantive, is a legitimate aim. So I don't know what will say the European Court. Thank you.
Actually, I would like to follow on this point, because, for instance, in Turkey, the identity card of males is light blue and females reddish pink, for example. I think that that is unnecessary, personally. I don't know what you believe, but I would presume that many of you are in agreement with me. In some countries, you have religion stated on the ID card. Is it necessary? What's the purpose? In our case, in Europe, we don't have these, but we used to have, in some countries, reference to the legal status of the person, whether they were married or in any other status. And so what's left on the ID card that is contentious from the LGBTIQ point of view is the reference to the sex, right? And the reference to the sex is, in my view, unnecessary on identity cards, especially in this day and age where with a QR code you can do so much, right? So there were days where identity cards were handwritten, the picture was inadequate to say the least, etc., etc. Today we have so much security if we want to, that online we all have a personality, you can buy, do things and so on, and it's secure enough apparently. So why do we need certain characteristics on our documentation? One thing I often say is that people run to buy the new phone, whatever brand they use, supposedly because it's going to bring so much innovation to their life. Same people often struggle to refer to a colleague as she rather than he 15 years after the transition. I think some people just have to get real on the reasons as to why they don't remember certain things. And let's face it, there's a lot of these, therefore, things that have become fossilized in the way we live in society, right? Old documentation, old systems that are in place, that stayed in place, that we can't really explain why we really need them, but some people now start to insist on why they need them, and this is where J.K. Rowling becomes very important. And this is where the fight around sex and its definition in law is so important. And this is why a judge that refers to gender reassignment and legislation from the 90s by way of backing a trend that is going down the wrong pathway, I think, again, there is a lot of problem. And so we need to find a way to articulate these things in such a way that the same people who seem to have garnered so much air in their wind sails finally have their sails with no air and ours start sailing again. I think that is a shift that needs to happen, and it's a shift that requires articulation actually. But it's a different kind of definition, not necessarily in law. It's the way we articulate it in society to ensure that people understand where we're coming from and why we're doing what we're doing. This is not some new fad, new trend, new anything. This is what is necessary so that the people who have had their human rights broken systematically start to live like everybody else without such violations.
Thank you for these great comments and answers, the three of you. During this time, did new question raises from the audience? Yeah, you can have multiple questions. I did. You can do.
I have more of a question on the, like, let's say, negotiation that has to occur when people don't have the same comprehension of the same concept, both in like finding a definition and then enforcing it. Like, for example, there were some mentions of we don't always have a corresponding word for each concept. How do you deal with these issues when you have to translate a text and you don't have the corresponding concept in a target culture, for example? I don't know if I'm clear.
Mm-hmm. Thank you, Maud. I think that this question is also very important in the Slavic context, where there is not always a word to say gender, for instance. So who wants to start with this question?
Oh. I feel it. Well, firstly, who are we? What's the negotiation and between whom? there are negotiations that are hard to have, like, for example, between the black person and the racist, for example, right? Let's not have that negotiation. Likewise, let's not have the negotiation between the trans person and the sexist, right? Or the trans exclusionary person. So there are negotiations that can be had, others just cannot. And so when we define in spaces where we're defining with the intention of doing good in the world, therefore, we're defining around traits and characteristics that define a particular group, but not from a discriminatory angle, but from an angle of identification, right? Of course, definitions have to be closed-ended enough that they make sense rather than include everybody or all issues, right? So yeah, I guess terminology develops organically in this sense. Universities contribute, civil society contributes, institutions contribute, and finally you have definitions that become fairly standard. I think the Yogyakarta Principles, for example, did this a lot for the LGBTIQ community, but 10 years later, we discovered that there were gaps and we had to revise. And I think that effort will continue into the future. To be slightly controversial, I think most LGBTIQ terms are actually obsolete today. Just mentioning, if there are more than 2 genders, how can you be bisexual? If being transgender is internal to you, what are you transitioning towards? If intersex is how to say, happens in nature like men and women do, what is inter between? And so all the language actually needs a revision. Personally, I prefer the term queer because it's the big box that includes everybody without any of these problems. Also, frankly, presence in the acronym. Why do you have LGB for sexual orientation? T, just one, quick and over and done with. I, just one, quick and... So, you know, it's a question of who is occupying the space then. And how did we, LGBT, how did it develop over time? There's a lot to say. I was very quick about this. Of course, if somebody hears me just say this, it's a big Pandora's box that I opened. But I think you all get the drift that language is constantly evolving. And precisely because also the way we live changes, hopefully improves, we'll start to see more and more difficulties with the current definitions and will hopefully improve them.
Raina, would you like to write?
Yes. I'm not so inspiring like you. I have a more legal perspective. For example, legal translations are very difficult because behind every word there's a legal institute. I don't know if you're from social sciences or law. So there's no even absolutely the same meaning in contract law for UK law and for, let's say, Polish law or Bulgarian law. So there's a whole construct behind that little word. And the second is it's all a matter of interpretation and knowing what is the aim. I recall the Dutch Supreme Court, Supreme Administrative Court. In the Dutch Constitution, which is from 1830, it's like a dinosaur, it's explicitly forbidden for courts to interpret laws in relation to their compliance with the Constitution. But the court one time decided on a pension case that some law was explicitly discriminatory and unjust in a very flagrant way. So it couldn't have been the intention of the legislator to apply it this way, so interpret it this way, so it must be interpreted that way, most likely. So it's all about the aim. I'm sure at the negotiation table, people are not sitting and plotting on doing bad things, I don't know, against human rights.
I take the mic. Well, thank you, Raina, for these answers. So, final question.
I'm not sure my English is sufficient. Okay, I tried, but I want to say something. Then I try. I'm a mediator. Then when you speak about, you talk about negotiation, I think it's very important today to find somewhere to debate. And you say it's not possible to debate between a black man and a racist. But I think we have to make a lot of way, a lot of space, a lot of des lieux, places, thank you, to debate, to make debate. I can see like that. And I think it's a way to make better human rights and better way.
Thank you. So indeed, today I think we try to debate on definition. Of course, both sides were not represented, but university is indeed a place to debate. And actually, if you go on our website, we had such a debate, including definition on gender, with Professor Robert Wintermute, who came 2 years ago in January, and we had a very intense debate, and Robert's conference in the past were cancelled because he's accused of being transphobic, and we did it here, debating, including the definition. So I do agree. I think that what Silvan meant was, if you are about to debate, you need some rules. So if the rules doesn't forbid you of saying a racist statement, then there is no debate possible. You need to debate in a rational way. Silvan, a quick answer?
Yeah. Very quick. So, on debate, I fully follow you. And I agree with you. So you're right. If we can't debate between us, nothing will change. And the persons who have their views set will continue to hold those views forever. So that's the way it is in society. We have to debate and we have to convince. I fully agree with you. When it comes to defining human rights, however, that's not the space to debate. Human rights, if we are allowing in the room the racist and the human rights defender, we've already lost the case. Because human rights cannot be negotiated on that front. Human rights are universal, indivisible, etc., etc., etc. And the moment somebody wants to chip away at that for some groups, if we accept that possibility even, I believe we would have lost. This is my position, of course, but I think it's an important distinction.
So it's time to close this symposium, and by the same occasion, the whole teaching intensive week we had. If I can keep one fond memories of this symposium, it would be all of you in this room listening so carefully. And I hope that in the future you will use all the skills, legal and non-legals, that you learned to make society better. Thank you again for taking part in this event and to the whole world.